In today's video, we are going to talk about court summons. We're going to talk about some of the things that you need to watch out for when you have a court summons from a debt collector. And these are some of the tricks that they'll play that I see done over and over and over again. And I don't even know why some of the attorneys don't even pay attention to this. I've had people contact me where they said that they hired an attorney to actually fight their debt collection lawsuit, and the attorney either just was not familiar with some of the things to look for, and that they mainly focused them on doing a settlement. And there is nothing wrong with doing a settlement, but you should go through the entire process of making sure that the debt collection company who is suing an individual in court did go through and get all the proper documentation to prove at minimum the amount that they're trying to sue somebody for. And then also I want to give myself a hand for something that I've seen a lot of attorneys doing right now on their videos. I want to give myself a nice applaud, because I think that the work that I'm doing here on YouTube with the Credit Repair Shop, with helping people who are being sued by debt collectors in court for debt that they've purchased from original creditors, that now it looks like the way that I've, in a way, taught people how to fight their case, there are a number of lawyers that are now taking on, I guess, my training in a roundabout way on helping their clients that are in their area with their debt collection lawsuits. One of the things, if you go back and look at my videos way back in the past, I had always said, if you're going to go into court and you're not an attorney, but they're going to expect you to put up a fight as if you are an attorney, which is crazy. And they'll make you think that if you're not an attorney, you don't have a right to defend yourself in court. You get that feeling. They don't say it, you get that feeling. And then some people end up getting an attorney and they end up not fighting the case. They end up actually just fighting over the amount that they owe, when you have a right to actually look at the information that they've presented and make them prove it, and then have the judge make a decision on it if they don't decide to dismiss the case. So the thing that I had said, you look back in my videos way back in the past when I first started, when I had a little bit more, I had hair on the top and not this beard and all of this stuff, is that I said the way to beat third-party debt collectors is through their own documents. Because what they try to do is they try to flip it and say, well, hey, you need to produce some documents. You know, in a way, it's like they're trying to make you build the case against you. You don't have to supply anything. What you do have to do is you have to put together an argument that's going to, or slash affirmative defense, that's going to give the court, give them something to be able to say, Mr. or Mrs. Attorney for your client, the debt collector, you need to provide these documents or provide this information to prove the debt that you are trying to collect from this individual. So now I want to talk about some of the things that you need to watch out for. Like if it was like a basic, because if it's too much, a lot of people get confused, they get scared. The more information that you would have to look out for with a debt collection lawsuit, you might get afraid and you'd be like, I don't know what to say, I don't know what to do. So I'm just going to make it very plain and simple in this video on what I want you to look out for. And then as you get comfortable with that, you can look at some of my other videos, or it might be revealed to yourself because you have a level of comfort with what I'm about to tell you, with the basics on how to fight a debt collection lawsuit. Because once you get comfortable there, then your mind is open to looking at the other problems that your case could have from the documents that the debt collection company gave to the plaintiff attorney for the lawsuit. So now first, let me just draw this out for you, because a lot of people skip over and don't even understand that everything we do in this world is a process. Look at right now. I want you to look at the image that's above me right now. You have very poor, poor, fair, good, and excellent. This would be a great example for you to understand how processes work. So if you, let's just say you want to work your way to excellent credit. If you have very poor credit, what would be the next step to get to poor credit? Because you can't get to excellent credit without going through poor, fair, and good. So what would be the next thing that you have to do to go from poor credit to fair credit? In your own mind, I don't even want to put any preconceived notion in how you got to do it. What I want you to understand is that there's a process. So if you're going to go from fair to good, in your own mind, what would you have to do? And if you were to go to good to excellent, in your own mind, what would you have to do? The lesson in that is that there's a process. So now I'm going to say something. You are being sued by, let's just say, LVNV funding for a debt that they purchased from the original creditor, let's just say Capital One. So let's break that down. You are being sued by LVNV funding for a debt that they purchased from Capital One. So now there's going to be a process that they have to go through to, number one, buy the debt. Number two, to come after you to sue the debt for the debt. And they purchased it from the original creditor. So now let's break down some steps in here. Number one, the first thing is that LVNV funding is going to hire an attorney to sue you in your area. So that's step one of the process. When they hire a collection attorney to sue you, that attorney right there automatically is now in the process where they have to do what's required of the Fair Debt Collection Practices Act. But because people don't understand the process, people will usually just focus on LVNV funding without even understanding that debt collection attorney, which they are hoping that you don't even ask these questions, because they have a responsibility to do exactly what they're claiming, their client is claiming with LVNV funding. But they don't want you to know that. So, step one, you are being sued by LVNV funding for a debt that they purchased by a debt collection attorney who is suing you in your area. So step one, if we just look at step one, is that in your response to the court summonses, you could challenge that debt collection attorney where you're challenging LVNV funding through their debt collection attorney, but you let them know that they have a responsibility according to the Fair Debt Collection Practices Act to make sure that all of the information that they got from their client, LVNV funding, is 100% accurate. This is the way that a lot of the debt collection lawsuits that we've assisted people with were actually dismissed, because that attorney is going to turn around and say, LVNV funding, we need everything. I can't be up in here in court just taking your word on it. And so now that gets to the other part. They purchase the debt. They purchase the account or whatever. In their documents, if they did what they're supposed to do, I've seen sometimes where they didn't even do this, is that they're going to put in there a bill of sale. A bill of sale from the original creditor. Or it could be a bill of sale, which is crazy. I've seen this, where it'll have several other collection portfolio companies in the chain, and then it got to the company who has the debt. You need to read you need to read and reread and reread and reread that bill of sale, because you will start to find when you reread it. That's the way that I did it. I just kept rereading. I was like, something doesn't seem right. You purchased the debt. You're claiming you purchased the debt from the original creditor in your summons, but you gave a bill of sale that said you purchased the debt from not one, not two, but three different portfolio companies. And I've seen it. It'll say Resurgent, Sherman Acquisition 1, Sherman Acquisition 2, Sherman Acquisition 3. So it's like, why are all four of these companies in there when you're saying that you purchased a debt in the court summons, that you were assigned the debt in the court summons? Like, you didn't say in the court summons that you had the debt from Resurgent, Sherman 1, Sherman 2, Sherman 3. You said that you purchased the debt. So that means that now you are passing down a debt from three other portfolio companies, and now you didn't get documents directly from the original creditor. You got documents from those debt collection or debt portfolio companies. This is the information that you would use in your summons response to that plaintiff attorney. So you're notifying them, hey, I know this with the documents that you gave me. Remember, I said you used their documents against them. They gave those documents. They gave those documents to beef up their case, and because they're required by law to give those documents, but it's really to beef up their case. Hey, this is the bill of sale. We got it. So you look at that and you look for any inconsistencies. You look, and some of the inconsistencies may be that they did not buy the debt from the original creditor. That is a problem right there. Next thing that you want to look for is the dates within there. I've seen where a portfolio had a purchase date that was before the date of the charge off for the client that they were trying to sue, for the defendant that they were trying to sue. So how are you going to buy a portfolio and then you have a date that's before when the person even had the debt charge off? They are actually doing that. And then what they'll do is, what I see now is they'll have like an amendment. So it's like, okay, you bought this debt, and you said, okay, it counts for debt in the future. It counts for debt in the future? Basically, that's what they're saying. And so you just trapped them right there. It's like, you bought a debt. It's in this portfolio. The person signed off on it, which is the next thing that I'm going to talk about. Someone from your company signed off, and someone from another company signed off, and it's before this individual that you're suing in court, the debt actually charged off. That's crazy. And then now let's go back to signatures. You're going to have a signature from the company saying that they sold it to the debt collection company. Now, but wait, hold on. Inside of their document, it said that it was sold to Sherman 1, 2, 3, and Resurgent Acquisition. So why involve all of them if you sold it directly to the plaintiff or LVMV Funding, who is suing this individual right now? The reason why is because there's other documents that they did not supply. There is another bill of sale, and that bill of sale could be with Resurgent first, Sherman second, Sherman 1 second, Sherman 2 third, and potentially Sherman 3 fourth. So with the chain, there's going to actually be another document, and this is the key word that I want you to look for in the documents, so you will know that there's documents missing, is that they will say that there's an addendum to the bill of sale. I'm looking at one right here. On this one that they sent, that a client sent to us, it said there was an addendum to the bill of sale. If there's an addendum to the bill of sale, where is the original bill of sale? You use their own documents to win your case. Now, the next thing that we want to look for, and on those signatures, you look at those signatures, because sometimes those signatures are robo-signed signatures. Look at them and look at the dates. I've seen it where the date didn't match when like the date that they supposedly had purchased the debt did not match the next document that I'm about to talk about, which is the conformity of the portfolio, the conformity statement. Let me bring one up here. This conformity statement is something that you need to watch out for. I'm going to bring one up here. Okay, so it's normally called certificate of conformity. There's another one here that I'm looking at for a recent one. It says affidavit of accounting and verification of business records. Basically what that conformity is that they're just stating with an affidavit to say that the records of the company, someone is certifying that they got the records a certain way, that they here, I'll just read it. I don't want to, let's not guess at this. It says here in with this company, it had an affidavit and personally acquainted with the facts herein stated. I am in charge of the records for, and they'll say the debt collector. And it says that talks about how their company is organized. It says, in such capacity, I am the custodian. They got even misspelled this word wrong. Custodian of the business records of such company, and attached hereto are the pages of the records which are kept and maintained under control and supervision in the regular course of business by employees or representatives of the company with knowledge of the acts, events, conditions, opinions, and diagnosis recorded to make the record or transmit information therefore to be included in such record, and the record was made to or near the time of the act, event, condition, opinion, or diagnosis. So you want to read that, and you want to look at that affidavit to make sure that stuff is correct with that. But here's the problem. Here's the problem. Is that with those records, they still never state any account information, any debt amount information, nothing. This is like if you can envision this is like an umbrella over the entire whatever they want to do. They could actually use that conformity for anything. Like when I started looking through these court summons and I was like looking at these documents, it was like if you kind of backed off and you were like paying attention to each one. So they're using it to build their case, but if you look at each one, you're like, this stuff here, if you don't read through it and you just look at the headline like we do with a lot of stuff, like looking at a YouTube short for a court case, if you look at it and you don't read it and you don't understand it and you don't challenge it, yeah, it makes it like it's an open and shut case against an individual. But if you read it and you start saying, well, it's missing this or it's missing that or this doesn't make sense, signatures aren't matching, account numbers are missing, the amount of the debt is not stated here in this portfolio, like a whole bunch of stuff is missing. And that's like, if you just look at like what can I do just to push this forward, just to have more time to be able to see what I want to do with the case, just challenging and looking at that information right there is enough. Just looking at that information right there is enough. Now there's more stuff that you could do to really put a lot of pressure on them to potentially get them to dismiss the case, or to have the judge dismiss the case, or to get you into a very good settlement position. But just that baseline right there. So let's just review. If we want to not put ourselves into a position to where we're trying to look like like look like Johnny Cochran out there. We're not trying to be fake and do stuff like that. What we're trying to do is to just state, in a layman's term, what we believe is some trouble that you see with the case. Because if you don't state that you feel that there's some trouble, some things that need to be looked at, they're just gonna go with the process of file, hearing, judgment. They're just gonna ask you, do you owe this money? If you don't state any problems, here are your easy problems to point out. How did you, prove to me how you came up with this amount of the debt? To not be just confused with prove the debt. How did you come up with that amount? The collection attorney lawyer who they hired for the plaintiff has a responsibility according to the Fair Debt Collection Practices Act, and you can point that out to them, that they have to do a debt validation. They cannot just take the word of their client. And remember, there's a process. The next process, just like I said, with that going from very poor credit to poor, fair, good, and excellent, that next process is the documents that they're going to supply to you. So you have a debt collection company buy the debt, sue you for the debt from the original creditor. Okay, let's get into those documents that you're utilizing to prove who you claim in the summons that you purchased the debt from. You look at that bill of sale. That bill of sale, does that coincide with what they claim in their summons? Or does it show that they potentially purchased it, or not potentially, does it show that they purchased it from other portfolio companies? It will state it in there. So don't worry about, where you're guessing. It will state it in there. You say, if they don't provide you that documentation, then that's a document that they're missing, that they're required to show you when they purchase debt and they're trying to come after you for it. They can't just say that you owe debt just because they have a partial account number and some statements. How did you get the debt? How do you claim you're controlling this alleged debt? And then how did you come up with that amount? Are you just taking it off of a piece of paper? So you want them, and this is the shortcut way. Just, because some people say, we don't want to have your company do it. And some people say, Steve, you don't give us any information on how we could do it. I'm giving it to you. So we have making them prove how they came up with the claim amount, and that debt collection attorney has responsibility to do that. Next, the documents that they're using to prove that they own the alleged debt, and who did they buy it directly from, or does it show in that bill of sale that they purchased it from a group, one, it could be one or another group of portfolio companies. Another thing that just came to my mind is when you read through that, some of the times, if the original creditor states, don't sell it to no one else. If you're not going to go collect it, you need to give it back to us, because we don't know what the next debt collection company is going to do, and we don't want to have our name co-signed on there and end up being responsible for someone else that's breaking the Fair Debt Collection Practices Act, which in a way is what they're going to be doing if they continue and they don't have all the documentation to prove that they could come after you for that debt. And that if you end up trapping them and they say, well, we made a mistake, or this was something that we shouldn't have done. I've heard all different types of excuses when they try to back out of the suing a person for a debt that they were trying to sue them for. They will say, it was an accident, or we dismissed it, based on this. And you're like, well, if you're dismissing it based on that, you should have never came after me for this debt. And original creditors do not want to be held responsible for that, because you kind of say, even though you sold it to them, there was problems with the paperwork in the transaction with selling the debt to them, or you had in your contract that they were supposed to give that back to you if they and not sell it to another debt collector. So we want to make sure that the dates are matching. We're going to make sure that it's if they're stating that they purchased the debt and they're not put, and it says in their bill of sale that it was purchased from these different portfolio companies, that's another thing that you need to put in your argument, in your affirmative defense. Also, that conformity statement or the affidavit, it just depends. Some of the times they'll put it in there, some of the times they don't. You want to make sure that the documents were transmitted the proper way. You just want to make sure that and so you just want to make sure that they have all of that stuff, those documents. Another thing is redacted information. This is but because when you put them into a position where you're calling them out on redacted information, on information that is not shown to be able to for them to prove their case, they start to unredact information. And one that I'm looking at right now on the bill of sale is that they had redacted at first the total amount of debt that they purchased, the number of accounts, and then they ended up unredacting it. And it doesn't matter if they redacted it; doesn't show the individual's specific account, and if they do have it redacted, it makes it look worse that they don't have the individual's account. I believe that when they first were doing this, they had it redacted and it'll say like total unpaid balance. And when they so just think about how that document would look if they say total unpaid balance and it has it redacted. In your mind, let's just say that you're the judge. What do you think logically would be in that amount right there? Even though it says that they're purchasing the debt from a total portfolio debt, just how do our minds work? If you're being targeted for the debt collection lawsuit, the amount they're trying to sue you for is $10,000. They put a document inside of the court summons showing that they purchased the debt from the original creditor. They black out the section that says total unpaid balance. What amount does your mind logically skip to be that total unpaid balance that they have redacted? Obviously, it's the individuals. They make it's like making an impression that it's going to be that individual's unpaid balance, that they just have it redacted for whatever reason, just like they redact the account number. This is how, remember when I say how process works. In your mind, remember I asked you, like, y'all got to pay attention to me because I'm doing more than just teaching you about credit. I'm teaching you about how the human mind works. And when you start to understand how the human mind works and how it skips ahead, you will start to understand how you can actually fight back against these debt collectors and how you can fight these court lawsuits. Because that's actually what I did, is when I figured this out, is I was like, I'm always anticipating the next move. And when I started to look at how they put together the court summons, they were anticipating the next move of the judge. Like, is this the proper venues? All of this stuff is the way that you have to properly put stuff together for a court summons when you're trying to sue somebody. But if you look at it, it's always a next step. Like when you look at a court summons, proper venue, are you suing the person in the proper venue? But if you think about it, that's an anticipated question that the court would ask. Are you suing? Is this person in our venue? Yes. What is the amount that you're suing them for? This amount. What is the account that you're suing them for? It was these last 4 digits. How did you get this debt? Well, we were assigned this debt from this creditor, from this original creditor. Okay, and then they start going into they enrich themselves. Like, well, what's the big deal about this debt? Like, why would they put the word enrichment in there? They put it in there because that's how our brain takes another step forward. Like, we're always one step ahead. So if I tell you, uh, you know, you fight back against debt collector by making them prove the debt, then you start saying, well, how do I make them prove the debt? Well, you make them do a full accounting of the debt. Well, okay, they do a full accounting of the debt. What's next step? Next step is making them prove how they got the debt. Okay, what's next step? Making them prove all of the documentation is uh, is accurate on did they buy the debt or did they buy the debt from another debt collection portfolio company. Okay, then what's the next step? Well, then make sure that the documents that they give you, if they purchased it directly from the original creditor, that it states everything in there, that the charge off date and everything matches, signatures match, all the dates match, everything, that there's nothing wrong with it. Make sure that there's no addendum to it that says that this was part of another contract. Where's that original contract from the sale of the debt portfolio? Like, all of these things is like a process. And if you just think about how your mind works, where you're always asking that next question, or you're always anticipating that next question, that's how you actually fight and line up your defense when you are fighting back against debt collectors. Like, you're anticipating what they're gonna come back with. But the only little difference that we make, because we understand that, people are not attorneys, we're not attorneys, is that we want to put this in layman's terms to actually explain it out to them and make them think about, hey, we don't have that, or we do have this, but it's a little bit confusing, or it's incomplete, or it actually makes us look like we're in a bad position if we try to move forward with this. That's basically the whole thing that you're trying to do, and it's all based off of the documents that they give, with adding that additional step of making them prove how they came up with that amount. And you need to ask it the right way. How did you come up with this amount? Show us all of the accounting records. If you're the original creditor, they would be able to give us all the accounting records. So if you're now take over that accounting. Remember when I talked about that conformity? Okay, on that conformity, I had read it. I don't want to read it again, but it said that they maintain the documents and that they know everything about the documents and that it was transferred here and there, all of that stuff. Well, if you got that, you just made that statement right there. Well, go ahead and give that to us then. They're like, oh, we don't have it. We don't have it that way. Even though we said we had it that way, we don't have it that way. We didn't mean it that way. Well, then what way did you mean it when you gave this affidavit of accounts, or that certificate of conformity? What way did you mean it? Because the way that you put it in the document, you can't even supply the documents the way that you claim that you're maintaining the documents. And that's how you make them dismiss your case. That's just part of it. That's just part of it. If you have a debt collection lawsuit from the original creditor or debt collector, they're trying to sue you, we will review your documents and tell you some options that you have. The link is below this video. If you have debt collection lawsuits, we can either help you with your response, or we can train you how to do your response. I have two different options in there. If you need help with your credit, please visit thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. That's the way that we repair credit. We don't promise overnight success, we promise hard work. Hard work gets you somewhere. It's just like walking up steps. You got to keep walking up those steps to get you to where you want to be. Link is below this video. If you need help, if you need your credit reports and scores, nothing starts without knowing everything that's on your credit, so you can know where you need to what needs to be done to be able to get you to excellent credit. That's a process. So if you got very poor credit, the first step in the process is to understand what's on your credit report so you can at least, at minimum, know what you're facing to make that next step in the process of deciding to want to work on your credit. And if you have debt collectors coming after you, grab my 3-pack of letters. You can stop a lot of debt collections with my 3-pack of letters. Statute of limitations letter for debt that's past legal statute of limitations to collect. Cease and desist collection activities letter for where you're going to challenge to make sure that they have all the appropriate paperwork. And this is way before they come after you to sue you. You could stop it potentially at that point. Or get documents so you could be prepared if they try to sue you in court. And the debt validation letter that you could use to go back and forth, because some of the times they will not give you everything that they're supposed to give you. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.